This meeting is now being recorded.
Great. Welcome, everybody. This is the next in our continuing series of educational programs, and today we're going to be talking about different types of cash or other personal property collateral which may be part of a real estate secured transaction, but for reasons we'll discuss, are treated separately and many times are subject to much different rules than the real property collateral. On the other hand, in the states in which Umpqua does business, there is an interplay between exercising personal property remedies and real property remedies that quite frankly doesn't exist in the Midwest or in the East Coast. But it is because we have a much more refined and I think highly sophisticated real property collateral set of laws. I think people in the Midwest and the East would say we have a confusing or incomprehensible set of laws. But what I'm going to try to do here is demystify the way that these work together, give you some options, explain how the documentation should work, and what remedies you have available. So to me, whenever I start thinking about the issue of additional collateral, again, I always rehearse in my mind, what are the recourse opportunities under the loan? Is it going to be a full recourse loan? Is it going to be a partial recourse loan? Is it going to be the classic non-recourse with bad boy carve-outs? In all of those instances, there can and is a place for additional collateral to provide additional protections, and it's important when crafting the documents that you explain how that collateral fits in with the recourse. Now, as we've discussed in the past, there are some de facto or just automatic recourse limitations that are baked in certain structures. For example, if you have a single asset borrower, a full recourse loan to that borrower is effectively limited to the collateral that is pledged by that borrower because they have no assets other than the property and perhaps cash, capital, and other related items for the ownership and operation of that property. So in such case, you may have a third party, such as a guarantor, or an owner of the entity who maybe is not signing a guarantee, but is providing a third-party pledge of either additional real estate collateral and or additional personal property collateral. Where we see this a lot in practical senses is you see it a lot if there's a letter of credit required. So, for example, you may have a single asset borrower and it may have two individual members. That borrower is likely not going to have a relationship with a bank sufficient to get a letter of credit, even a cash secured letter of credit. Typically, it's going to be one of the borrower members who are going to have that relationship. So in that case, the letter of credit that will be given to the bank for additional collateral will, in a sense, be pledged by that third party. In those instances, I want you in your mind, whenever you have a third party who is pledging collateral, even if they're involved in the ownership entity so that they can give this additional collateral and you have sufficient consideration, in your mind, whether or not they're signing a guarantee, think of them for purposes of Idaho, Washington, Oregon, California, Arizona, Nevada law. Think of them as a guarantor because they are, in a sense, by pledging this additional collateral, they are providing recourse, at least partial recourse to that collateral as additional backup for the loan beyond the borrower obligations, and that can and typically is viewed by courts as a guarantee. Now, that doesn't mean you have to have them sign a guarantee. What it does mean is in your documents, if you have that third party who's going to be putting up this additional collateral, we need to make sure that your pledge and your security agreement documents contain the necessary state-appropriate guarantee waivers. So I just want to plant that seed that you think of these third parties as effectively a limited guarantor, because that's how the law will treat them. Obviously, there will be contractual recourse limitations. Some of those are the bad boy carve-outs, or some are when you have passive investors or shielded owners. Really what that means is if you've got an LLC, it's the LLC members. They're not directly liable. If you have a limited partnership, the limited partnership owners are not going to be directly liable. And same with a corporation. The shareholders are not directly liable. So if you want to get recourse, or like I said, if you're getting a pledge of additional collateral from those individuals, you will want A, an agreement with them, and B, you'll want to recite in that agreement both their relationships so you have consideration covered, as well as we'll want to make sure to put all the necessary guarantee waivers. The relationship of the entity structure to the loan structure when you have additional collateral, again, is always important from your standpoint. When you're underwriting and looking at management, you're concerned about the stability and continuity of management. That's why we have due on sale restrictions. And you're also interested in the source of the capital funding. Is all the capital in the deal up front? Are there going to be the need for future equity contributions? Here's where that may apply. You may be doing a loan that contemplates or anticipates that there are going to be capital improvements, repairs, maintenance work that is required down the road. You may or may not be holding reserves or impounds for those. In that case, you'll want to make sure to take a look at the operating agreement and see, is there going to be a party who is obligated to fund those improvements, that work, those additional costs? Because in one way, shape, or another, you're going to want to make sure that the documents appropriately acknowledge how this work or how these improvements are going to be paid for, who's going to be responsible, and how is it funded. If it's funded through a holdback, then obviously you're going to have an agreement for the reserves or the impounds, et cetera. And if it's coming from one of the members, you'll certainly want to put that requirement in, most likely as both a covenant and as an event of default. So if they fail to do the required work and pay for it, then you have the ability to declare default. So, some alternatives to non-real estate protections. Everybody 15 years ago used the phrase lockbox. I think the whole world now has changed to the phrase cash management. There's no difference. A lockbox agreement and a cash management agreement are exactly the same. Just one sounds a little more warm and fuzzy. And so we use cash management because it doesn't sound so harsh. You can use a cash management agreement for simply monitoring the income of a property and making sure that it's coming into a restricted account and that it's being applied in a particular manner. That may be the protection that you're looking for. For example, if you do have capital improvements or other work that needs to be done on the property and you want to fund a reserve or an impound with excess cash, you can use a cash management agreement where you establish an account with the bank, have the revenues come into that account, and then have a waterfall as to how they're to be applied. Typically, a cash management agreement, at least with your bank and with most banks, treats the waterfall or the distribution of funds in two different manners. One is the pre-default use of funds, and one is the post-default use of funds. That's what's known as a springing lockbox or a soft lockbox that goes hard. I don't see a lot with your bank, or frankly with most banks right now, anybody doing hard lockboxes from the outset. I've done a couple of hard money loans with mezzanine lenders where they do in fact require a hard lockbox because they want to make sure every penny is being applied appropriately and that there are no distributions made. But in a bank loan, usually prior to default, the borrower gets to apply the funds that come into the account. They get to apply them per the waterfall. Normally, there will be a set aside for any monies that need to go into a reserve or impound account or sub-account. And then the excess can be retained by the borrower. And of course, that changes upon default. In that case, the fund is shut off in terms of access by the borrower. It becomes under the exclusive control of the lender, and the lender then has certain recourse to those assets in the account.
Hey, Ren. Good morning. Hey, Ren.
Yes.
It's Greg. Good morning. It's Greg.
Hey, Greg.
Hey, I don't know if I heard you say this or not, but you want to just explain to those that may not know what the term waterfall actually means. I mean, it's sometimes
Sure.
can be a little intimidating. I mean, it's a simple concept, but just so that they have that as a backdrop.
No, that's good. Sometimes I do get lost in jargon, so I appreciate that. A waterfall simply means the order in which monies that come into the borrower are supposed to be applied. So a standard waterfall would say that gross revenues come in, and first to be paid are the operating expenses of the property. Second to be paid is interest owed to the lender. Third to be paid would be principal owed to the lender. Fourth to be paid would be any portion of those revenues that would be going to fund a reserve account or an impound account. And again, if you establish an account with your bank, it's very typical to use a sub-account of this master account for the reserve or impound purposes. And then finally, you're going to have excess funds, and those excess funds can either be required to be held in the account until some event occurs, for example, until the reserve is fully funded or the impound account is fully funded, or the borrower can have access to those excess funds immediately to use for any lawful purpose. What you see then is a change in that waterfall when you have an event of default. And I appreciate the question, Greg, because a lot of what we're going to talk about is the nuances in how you set up your waterfall so that you avoid some of the restrictions imposed in various states in which you guys do business as a result of one-action rules. Most notably, that's going to be Washington, Oregon, and California. And the way you set up your waterfall and the way that you dictate how funds are to be used pre-default is very important as to what happens post-default. But post-default, the biggest difference from what I just described is you still want the money to go to operating expenses. You still want to pay principal, interest. You may at this point have costs that you're incurring, so you want those paid. And then the monies that are left over typically are made available to the lender to apply to costs for the property, protective advances, and or the pay down of the loan. So that's what a waterfall is, and that's what I mean
Joining the meeting.
Change in the waterfall resulting from an event of default. Another way of addressing some of these issues is through financial covenants. meaning covenants where the borrower, let's say you don't need up front a cash management agreement, but you want to make sure that your borrower is applying funds in a certain way, and let's say you do establish simply a reserve account or an impound account, but you're not using a more involved cash management agreement. In that case, you'd want a financial covenant that would effectively do the same thing. It would have your waterfall saying, when you get your revenues, here's how you spend it, and there's going to be a place where the borrower is going to be required to transfer whatever funds are required at that time into the appropriate impound or reserve account. Then in those situations, when you have a financial covenant, you will also want to have a covenant that says upon the event of default, there will be no distributions to the borrower, funds are to be turned over to the lender, etc. So you can use financial covenants in connection with these types of agreements as a hybrid rather than doing a completely blown up, big, involved 25-page cash management agreement. You can have a nice little comfortable set of financial covenants in your loan documents coupled with a more simplified deposit account agreement for the reserves or the impounds that you're going to be holding. I did want to mention, because this does come in as I described up front, when you are getting additional monies that are pledged or a letter of credit that's pledged or any other collateral from a member of the borrower or a partial owner of the borrower, these are alternatives to guarantees. So if there is a requirement, for example, for additional work to be done on the property, and for underwriting reasons you've decided not to require a reserve or impound, but you are concerned about making sure that there are monies available, you can have what's called a funding or equity contribution agreement. And what that really is if a member is expressly required to fund the work that you're concerned about under their operating agreement or their partnership agreement, you can have them agree directly with the bank that A, they will honor those obligations when required to do so, and B, if they fail, that the lender has the right to go to them directly and require the funding of those monies, which the lender will then make sure are applied to the necessary work. So again, this is the alternative to a reserve account or an impound account, but it's a way to make sure that you're protecting yourself for anticipated items that are coming up in the future for which you want to have protection, that work is being done to maintain the asset, that the collateral is being protected, etc. These can be used and typically are used without a separate note, meaning you don't include a note obligation from that equity investor. You simply have your funding agreement with them. We've talked about whenever you have a third party that's related providing some additional collateral, remember that they're going to be subject to some recourse limitations, either contractually or de facto, and you in your mind want to think of them as a guarantor so that we make sure we get the guarantor waivers. Finally, consideration is always an issue when you have a third party, and the easiest example I give in this instance is if I were to own with my wife an LLC and we needed to post a letter of credit as additional collateral to pay for some capital improvements that will be needed down the road. If I or my wife, as members of the LLC, go to our bank and we get a letter of credit and you then get a pledge agreement for that letter of credit from us, we certainly have consideration as the owners of the borrower. If my dad, being a good man, wants to help out his son and he goes to his bank, unless he has a financial stake in the property and or the borrower or the distribution of funds, my dad, being a good-hearted man, does not have consideration. Now, it is possible to do what we call buy a guarantor, meaning I could offer my father, in return for him posting that letter of credit, I could offer him certain distribution rights, or I could pledge to him certain income that the borrower would receive before it comes to me and my wife as consideration for him giving that letter of credit. In that case, you've created an appropriate third-party accommodator situation, but again, you want to treat my father in that instance, even though he's not signing a guarantee, you want that pledge of the letter of credit to both recite what is the consideration that he's getting, and in this case it would be some distribution from property revenues, and number two, you want to make sure that you put the guarantee or suretyship waivers, because it's very important that you treat him as a guarantor, even though he'll never be called a guarantor, and even though he'll never be treated as a guarantor. In effect, most courts will see him in that role and therefore offer him the protections of a guarantor. And that's really what you're trying to avoid. You don't want to create a situation where you've dotted all your I's and crossed all your T's in terms of consideration, but then you're stuck jumping through hoops under the real estate laws to treat this person as a guarantor who hasn't given the necessary waivers so that you can act against them directly and separate from your real property remedy. So I want to do a little bit of an overview of cash accounts, and this is similar to the nomenclature question that Greg had, because I do think it's important to draw a little distinction because we use a lot of phrases interchangeably, but there are some accepted in the industry meanings for certain of these phrases. And reserves tend to be loan funds that are dispersed and held in a pledged account for later application. Reserves can also be borrower funds, which are provided to the lender and held in a pledged account for later application. Those are reserves. Holdbacks are very much different. A holdback is always a portion of the loan that is either not funded at the closing and will not be funded until certain requirements are met for the release of those monies. So, for example, if you have a holdback to replace the roof on the property, or if you have a holdback until the borrower achieves a certain debt service coverage ratio. You will not be funding those dollars to the borrower until they've met the required hurdles in order to get that money. One of the questions you should ask yourself in that instance with a holdback is the bank going to hold back those monies and not disperse them until the requirements are met? Or do you intend to fund at closing the full loan and put the holdback monies in a pledged account with the bank? The only difference, as I'm sure you guys can easily figure out, is if you're funding on day one, the borrower is paying interest on monies that he doesn't have access to unless and until the monies are released to them. So it's usually not very popular with borrowers. If they're going to have a holdback, they typically want you to hold on to those funds until it's time to release them. But for business purposes, you may decide that you're funding the whole thing and you're going to put those monies in the holdback deposit and account agreement. In that case, the borrower, A, is going to be paying interest, and B, you're going to want to make sure that it's very clear in that deposit account and pledge agreement that the monies that you've dispensed, even though they're loan funds, they still remain as collateral for the loan and pledged for the loan unless and until the necessary requirements are met for the release of those funds. And that's a very important element. Impounds now are always borrower funds or property cash flow that is swept or provided to the lender to be held in a pledged account for later application. And you can have two different kinds of impounds. In your standard documents, under BC Docs and under more complicated deals that we do with you, you will always have what are called post-default impounds.
Joining the meeting.
For important property items, most notably insurance premiums and property taxes. So if there's a default, you will always have in your security instrument, your deed of trust, you will have a requirement that as soon as there's a default, regardless of what else is happening, your borrower is going to have to deposit with you on a monthly basis the 1/12 of the annual premiums for insurance and property taxes assessed for the property, so that you have those funds available either A, while you're trying to work out a resolution with your borrower, or B, as you're getting yourself ready for foreclosure, so that you will not have to make a protective advance and you will not have to go out of pocket and increase your loan exposure to pay those very critical collateral protection items. You can, however, and often do, have pre-default impounds. And those, again, can be for very specific items like an impound that will be funded up front by the borrower for maintenance work that is required to be done, let's say, within the first 90 days after closing, or repair work that is to be done within 90 days of closing. I want you to know, at least for the BC Docs documents, we do have an option that allows you to choose those pre-default impounds, and you can have your security agreement and all of the necessary mechanics for both the deposit of those funds and the release of those funds built into your note by answering the correct impound questions as part of BC Docs. Even when you have that, however, you do need separately a deposit account and control agreement, because you do need an account with your borrower to allow you to hold the monies in a bank-controlled account. And I'll talk about what bank-controlled means. Now, one question that we frequently get, and I want to kind of demystify it for you. How should you name the account? Do you put the account in the borrower's name and then provide that it's pledged to the lender? Do you put the account in the lender's name from day one so that they are the sole owner and holder of that account? Or do you put it in the borrower's name for the benefit of the lender? My recommendation is that as your basic concept, you use choice number 3. And there are two reasons why. One is you want to have an agreement where the borrower acknowledges that these funds are the borrower's responsibility, that the borrower has the right to grant to you the security interest and the control over the funds, and when the funds are held in the borrower's name, it's much cleaner for security purposes and lien perfection purposes to have it in their name. But you want it to be clearly identified that these funds are held for the benefit of the lender, meaning you're giving notice to anybody who may look at that account that this is going to be a restricted account, and it's going to be subject to a pledge agreement, and it's going to be subject to limitations. The other reason I favor item number 3 is that if you are going to be paying interest on this account, even though that interest likely is going to remain in the account, you are going to, we always put in a provision, if it's an interest-bearing account, that the borrower acknowledges that that interest, even though it's held in the account and has to be used for a specified purpose, is interest of the borrower and not the lender, and hence they have any tax liabilities, and they indemnify the lender from having any resulting tax liabilities. That issue becomes more complicated and difficult if you put the account in your name. The reason I don't like just putting it in the borrower's name and relying on the agreement is you've given no notice to anybody who may look at that account that this is a special account that has been pledged to the lender. So it helps you internally to name the account in the borrower's name, FBO, for the benefit of the lender. And so that's my recommendation. I think it's easiest. I think it provides all of the mechanics that you need, but it gives you the legal protections and allows you to structure the legal protections in the best way and most advantageous way for the bank. Now, I want to draw some differences between cash collateral and pledged accounts. Pledged accounts can be an account for reserves, impounds, or as we said, even fully funded holdback monies. And these accounts are established for a specific purpose. As I noted, you should name it in the name of the borrower for the benefit of the lender, and they'll be managed by the borrower prior to default. You want to specify in that agreement that these funds are additional collateral, because if there is a default, you want to make it very clear that any and all funds in that account are strictly under the domain and the control and the application of your lender, as opposed to the borrower having any rights. They need to waive all their rights in the event of a default. And you want to pay attention to your waterfall, which is how are the funds coming into the account, how are the funds going out of the account, and you want to be as specific as possible. A pledged cash collateral account is simply when you make a loan and the bank deems that it is not fully comfortable with the real property and that they need a little kicker, a little cash collateral to make sure that the underwriting is solid and meets the expectations or the policies of the bank. Here's where you might typically see it. You might have a property that right now is at a 1.15 debt service coverage. And you know that they're negotiating and maybe even have signed leases that will go into effect within the next 6 months or a year that will push your debt coverage ratio above 1.25 or 1.3, whatever it will be, but an area where the bank is more comfortable. For the interim period, you may request that there is cash collateral pledge that you hold in case there's a default or in case the leases fall through and they need additional time to find replacement tenants. In that case, it's a very simple transaction. For these kind of accounts, you don't have a waterfall. The money comes in. It stays in until either A, there's a release provision, meaning they've met the requirements that gives the lender comfort for the release of the funds and you release the funds, or there's a default and those funds are available to be applied to the repayment of the loan. So it's a little different than the reserve or impound accounts that we've been talking about, which talk about monies coming in a certain fashion, being applied on an ongoing basis according to a waterfall, and then excess funds treated in a specific manner. A pledged cash collateral account is obviously something much different, where you are bolstering your collateral with cash. You can do the same thing with a certificate of deposit. You can do the same thing with cash equivalents like fully marketable securities, or, as I mentioned, a letter of credit. All of those are cash substitutes, which you can and should be thinking about holding in these types of instances. And underwriting will decide what they're most comfortable with, and that's usually a negotiated item. Usually, for example, if the monies are going to be held for a long period of time, the borrower may not be satisfied with the meager passbook interest that will be paid on the account, and maybe wants to get a higher yield on those monies by getting a short-term certificate of deposit and then having that pledged in this cash collateral account. You can do that, and that's certainly acceptable, and it requires a little bit of modification to the documents, but it absolutely works. Likewise, they may want to give you a letter of credit in the same circumstance, and again, perfectly acceptable alternative to cash, and in fact, a letter of credit is the most golden alternative to cash that you can find, because whether it's a certificate of deposit or it's cash, if there's a bankruptcy of the party who gave you the cash or the certificate of deposit, it's possible, notwithstanding your lien, that a bankruptcy court could look at those monies and deem them cash collateral to be applied for a whole variety of debtor expenses which are outside the repayment of your loan and completely contrary to your loan documents. So you can be overridden by a bankruptcy court when it comes to cash or certificates of deposit. That can't happen with a letter of credit for one simple reason. A letter of credit is not owned, nor does a borrower or the applicant for the letter of credit have any legal interest in or right to that letter of credit. So, if the letter of credit is put up appropriately, you have the right pledge agreement, and the bank is holding that letter of credit in its own name, or it's been assigned to the bank in its own name, then those funds are the bank's funds, and they have legal ownership, meaning that a bankruptcy of the party who arranged for the letter of credit cannot claim a cash collateral right or any other right in a bankruptcy to a letter of credit. A letter of credit is golden. Why don't we do it every time? They can be expensive. Typically, banks want their letters of credit to be both cash secured, and they charge an annual fee for the issuance and renewal of these letters of credit. So the cost may be prohibitive, and that's why you don't always get a letter of credit. But if a borrower is willing to give one, and you have a choice between taking cash, certificate deposit, stocks, or any other marketable securities, you always want to choose the letter of credit if that's on the menu and being offered. The different types of security agreements you'll hear about is one is the general security agreement. And that's an agreement where it's established for a certain type of disbursement account. It's bank controlled when it's opened by the bank. There may be no restriction on the use of funds except in the event of default. And those basic collateral provisions are put in and triggered by an occurrence of default. This is most often seen for an operating agreement. If you require your borrower to open their operating agreement with you, you should always have a very simple security agreement for those funds. because although in the states you do business in, you have a statutory right of set-off to grab those funds upon a default and apply those funds to the indebtedness, that act of set-off can and has been held to violate the one-action rule. So the reason you need a separate security agreement and you don't want to rely on your statutory banker's right of set-off is so that you can mitigate that disastrous consequence and provide for the right alternative up front. The second type of an agreement is a deposit agreement, and more people are using the phrase DACA, D-A-C-A, and that refers to a deposit account and control agreement. And that's the type of deposit agreement that we prepare for you. It's the type of account that follows all of the rules we've been describing in terms of who has access to the funds, pre-default, how the waterfall provisions work, pre-default, what rights spring into provision as soon as there is an event of default, what rights do the lenders have at that time, and it's very specific. Those type of accounts will be used for your specialty accounts, your reserves, your impounds, your fully funded holdbacks. So it's different than the operating account system where it's a much simpler. Our operating account security agreement is a page and a half, and 3/4 of that are the recitals, and less than a half a page are the actual security provisions. Very simple agreement. A deposit agreement, because it has a lot more moving parts, it is going to have a lot more controls. It's going to have a lot more indemnification provisions to protect the bank. It's going to have a lot more recitation of who does what when, depending on the circumstances. And finally, you can have an ownership or proceeds pledge account. Now, this is interesting. This is when the bank decides, for example, that in addition to the real property collateral, they want to take a pledge of the membership interest in the borrower, or they want to take a pledge of the distributions and proceeds payable to the members under that operating agreement. In this case, you're getting a true pledged account where the lender is going to have rights to oversee management decisions, give consent to changes in the flow of the funds under the operating agreement, the use of the funds under the operating agreement. You're going to want to very specifically define both pre-default and post-default, how the lender is involved with the entity that it has a pledge of either membership or proceeds of. I have a deal right now where we're getting a pledge of both the membership interests as well as the distribution rights in the entity, and we're very careful to impose limitations which make sure that the operating agreement, which provides for as funds come in, they immediately go to the members. We want to make sure that those funds come to the lender for application to the pay down of the loan pre-default. And that's going to be important because I'm going to explain the difference of how the one-action rule applies in a pre-default versus post-default remedy. Finally, if you are taking an assignment of membership interest or stock interest, very often closely held entities do not issue certificates of ownership. They reserve the right to issue certificates of ownership. Our advice is to have them issue certificates of ownership because then they can deliver those to you by assignment as part of the pledge agreement, so that if you actually have to take control of the entity by exercising your remedies, you will not only have your pledge agreement, but you will have an actual certificate of ownership that you can show a third party to conclusively prove your ownership. It's a much more streamlined and efficient way of handling it. So my advice is that if you are taking an assignment of ownership interest, whether it's stock or LLC membership interest, ask them to apply or to create certificates of ownership, which they will then assign in executed form to you, and you will hold those, and they are only to be used upon a default, but that will give you something that you can show third parties when you're making decisions for that entity. I truly do own it because I not only have a security agreement, but I have these signed certificates. Very helpful. On the deposit account agreement, or the DACA, we've talked about most of this already, so I'll kind of skip through it. We've talked about the account being established with the lender or a third-party bank. Hey, let's face it, you guys are a bank, you're in the best world. Never let them establish these accounts with another bank. It causes two complications. One is you have to enter into a separate control agreement with that other bank, where the bank acknowledges that you have a pledge and you have control over those funds and you have certain rights under certain circumstances. But you also have to give an indemnity that says to the bank that as long as they're following the instructions of either the borrower pre-default or the lender post-default, that they're entitled to follow those directions regardless of any disputes or litigation between the parties, and it just creates another level of complication. Since you're a bank, always make yourself the deposit account agreement. The one exception I would say is if the pledge that you're getting is a cash equivalent, meaning a CD that is held at a different bank, or a securities account which is held with a broker. In those instances, you're not going to get them to transfer that relationship over to you, and you will always need the third-party holder control agreement. So you will have two agreements. One is your pledge agreement, and then second will be that tri-party control agreement with you, the borrower, and the other institution, acknowledging what your rights are under your pledge agreement. Now, I've used the phrase control over and over. Let me distinguish the legal terminology of control. I think all of us think of the word control is automatically, it's in my possession, I have the right to do whatever I want with it, and I am going to direct from day one how these funds are going to be applied. Technically, that's correct through the waterfall provisions and the restrictions that you put in these various agreements, but control really doesn't have that meaning in the UCC. Control simply means, under the UCC, that you, the lender, have the right in any circumstance that you contractually agree to limit, restrict, or completely impede the borrower from taking actions with respect to that account. And that at the end of the day, if there are third parties involved, depending on the triggering events for the exercise of those rights, you have exclusive ability to issue instructions or directions for the use of those funds. And so control doesn't necessarily mean possession. Control doesn't necessarily mean the right to handle the monies at the very outset. It has a particular legal meaning which says that you are going to be able to dictate, both pre-default and post-default, what happens to the monies. And typically in our deposit account and security agreements, we just recite very specifically that the lender has control for purposes of UCC 9104, which is the controlling provision that defines what this term means so that there's no confusion. And the importance of getting this control from day one is your security interest is perfected at that moment you get control. And that is crucial in a bankruptcy situation. Because if somebody springs a bankruptcy situation on you and you have not perfected your interest in the monies, meaning you have to do a second step to perfect your interest, you are much likely, in that instance, much more likely to have the bankruptcy court limit your access to those funds and to see those funds as potential cash collateral and not really subject to your control because you didn't establish control at the outset. Now, we've talked about waterfalls. Here's where I was going to define it. We've already kind of gone through that, but I do give you basic priorities. We've got about 6 minutes, so I want to cover a bunch of stuff here with you. We've talked about control. We've talked about the name of the account, and again, my recommendation is put it in the name of the borrower for the benefit of the lender for all the reasons we've described. We want to talk about the treatment of interest. Again, we want the interest to always be deemed income of the borrower because we never want the bank to assume some type of income for which they may have to pay taxes. And here's an interesting thing to note. Even though you, the bank, Umpqua Bank, will be both the lender and the holder of the account, you will notice that our deposit account agreements list you twice and treat you in two different ways. One is as the lender who has a security interest and certain control rights over the monies in the account. And then we have you in the position of the deposit bank, where you are entitled to follow the instructions of the parties as set forth in the agreement. You're indemnified from the borrower for following any instructions. You're not taking any greater obligations on, notwithstanding your role of the lender, that you simply follow the black letter rules of that deposit agreement. Separating you out in that instance is crucial because there are some cases where people were sloppy and treated the lender as the deposit bank and really didn't distinguish the roles, and courts always in those cases ruled in favor of the borrower and limited the rights and the protections that would be afforded to the lender acting in the role of deposit bank. So when you see us prepare one of these agreements and we've carved out the two different roles and we're going to have you sign the agreement in these two different roles, understand it's for your protection and it serves a very real legal purpose where if you don't do it, you put yourself at some risk. Some common uses of pledged accounts. You know, we've talked about this already. We've talked about the use of holdbacks, reserves, impounds, etc. The one thing I would introduce in this is the concept of a cash flow sweep. And more we're seeing all lenders use the concept of a cash flow sweep. And typically what you'll see either in your note or in your loan agreement all the provisions of when the cash flow sweep is triggered, what happens in the cash flow sweep, how monies come into the controlled account, how the monies go out of the controlled account, and that's usually set up in its entirety in the note or the loan agreement. That notwithstanding, you do need your deposit account agreement. One, because you want to create that tri-party relationship where the bank acknowledges it's a lender with certain rights, but it's also the deposit bank with certain protections. So that's very important. But in these agreements, we can make it very simple, because when it comes down to what happens with the money, we can just cross-reference what is otherwise in the loan documents. And although this document is necessary to establish the right roles of the parties pursuant to the account and the right protections, the guts, the important provisions, the waterfalls, the triggering events of when a cash flow sweep is initiating, the triggering events when the cash flow sweep is terminated. All of those contractual items will be in the main body of your loan documents and will not be recited in your deposit account and control agreement. The reason for that is quite simple. You want to be able to, in your note or loan agreement, tell the story of your relationship. And if you have a cash flow sweep, it is critical that part of the story you're telling is how that cash flow sweep works. And that's why we always put it in the body of the main documents and not in the deposit account and control agreement, because you want to be looking at that one singular account so that you can properly monitor when you need to exercise your cash flow sweep requirements and how that account is going to work. Then the actual deposit account agreement is rather simplistic to do the very limited things we've talked about. Other common uses, again, we've talked about pre-default impounds and post-default impounds. This is just really a checklist for your benefit. A borrower's funds account, this is a little bit different, but this goes to that instance where we talked about earlier, the borrower is going to be putting up its own funds either in the terms of cash or a deposit or a certificate of deposit or perhaps marketable securities, etc. That's a borrower's funds account. And that's typically where you're going to need a tri-party agreement separate from your pledge agreement. So I kind of give you some basic rules on that. I've run out of time. Susan, is it okay if I take about 5 more minutes?
Sure.
Okay.
I'll speak for Susan and I'll say yes. This is Cheryl.
Oh, okay, Cheryl, thank you. I want to make one really important distinction right now, and this is what I want to leave you with. In a one-action rule state, there's a very simple rule as to what rights do you really have in pledged cash, whether it's an impound, a reserve, a holdback, or a borrower's funds account for cash collateral. And here's what the rule is. You want to provide as much protection in a pre-default scenario in terms of the use of those funds, because anything that you're allowed to do in a pre-default scenario, you are allowed to unilaterally do in a post-default scenario. So, for example, if you put as part of your waterfall, hey, if there are excess funds, we get to pay down our principal. Hey, if there are excess funds, we get to put it in a separate account under our sole control. hey, if there are excess funds, we get to put those monies in an account where we can pay for various costs and expenses and capital improvements, etc. If there's a default, the default doesn't change any of those pre-default rights that you have. And you can absolutely exercise them both unilaterally per the agreement, and most importantly, do it without fear of triggering the one-action rule. So you want to give it very careful consideration as to how broad and how comprehensive you want to put your rights in your pre-default situation, because if you have the standard agreement which says we're going to have a waterfall to pay expenses, loan costs, loan amounts, reserve amounts, and the excess goes to borrower, and then upon default, no, the money's come to us, lender, and we get to apply them. In that case, the advice you will always get from us in a one-action rule state is, if the default is the trigger that allows you to apply those funds to pay down your loan, don't do it. Hold it in the account until a court orders you to apply those funds to pay down the account. Or you can turn it over to a receiver, and the receiver is ordered to apply those funds for that purpose. The reason being is the one-action rule requires you look to the property first after a default. And if you have a default, and even if you have an agreement that says, I can use these monies to pay down my debt, I can assure you that courts, and there is case law to support them, will say, no, I'm sorry, this right arose post-default, hence you are exercising or taking an action by using those funds to pay down the debt, which violates the one-action rule. And there's sometimes that's going to be the business deal. And it doesn't mean that you can't continue to accrue those funds. Doesn't mean you can't continue to hold them until there's final resolution and all that money will be made available to you. It does mean you're going to be in a delayed gratification position, which is not the worst position to be in, and it doesn't mean you're going to lose rights to those monies. It does mean that you won't be able to apply them to things other than what you allowed yourself to do pre-default, pay operating expenses, pay reserve amounts, whatever. And the one exception that the courts have acknowledged does not trigger the one-action rule is if you do have post-default monies that you're holding, you can apply those to make protective advances to protect the collateral. So if they're not paying insurance premiums, if they're not paying property taxes, if there's damage to the property which they are not funding, you can make a protective advance with those monies and not trigger the one-action rule. So that's why I wanted to take the 5 minutes. That's a big takeaway that I want to make sure that you guys really understand in terms of what your rights are, because we get questions all the time from lenders, even on docs that we didn't do, where they say, we have a default, what can we do with the monies that we're holding? And we always have to go to the express terms of the agreement, and we have to see whatever you could do pre-default, you can keep doing post-default with impunity. But if the right to apply your monies to the debt only arises in a post-default scenario, then you better hold on to them, and you better wait till a court gives you an order as to how to apply those to the debt. And you'll just hold those monies until you get to that position, which means you're going to have some litigation, either to appoint a receiver or as part of your non-judicial foreclosure, get an order from the court as to the application of those monies. We've talked about letters of credit. Don't really have to go into detail. We've talked about additional collateral issues as well as post-bankruptcy. The final thing I do want to say, and then I'll stop, Susan and Cheryl, I promise. I'm not going to take you any further because I've gone 8 minutes. So I'm going to take 2 minutes. I'm only 10 minutes late. And this is what I want to say. If you have pledged funds, whether they're reserves or impounds or holdback monies, that you are going to be using for the performance of construction work on the property. That can be repairs, it can be maintenance, or it can be capital improvements. In all of those instances, even though you have a term loan, even though you don't view this in any way as a construction loan, you will want to, in all instances, get your mechanics lien protection at the outset of your title policy for the use of those funds. Because a title company will look at those funds, even though they're reserves and may not even be lender dollars, they're going to look at those as expenditures which, under the standard policy, if there's a mechanics lien, they're not going to insure you for that mechanics lien. And you definitely want that protection. So the final big warning is, if you're setting up a deal where you're taking a reserve or an impound or holdback funds that you know are going to go to some type of construction work, you better be thinking about, and we can help you with this, getting in your instructions the provisions that you expect mechanics lien coverage and get the acknowledgement of the title company up front that the use of those funds fall within the mechanics lien endorsement, because those signed instructions together with the endorsement have saved our bacon so many times when there has been an advance and a mechanics lien has popped up. And I can assure you the knee-jerk reaction we get from the title company every time, even in a term loan or especially in a term loan, is, well, you don't have mechanics lien protection. And when we can point to the policy and say, no, you gave us the endorsement, number one, and number two, you agreed in your signed instructions that when these monies are applied, that's exactly the purpose for the mechanics lien endorsement. They have no defense, and they roll over 100% of the time. So believe it or not, I did get through my 18 slides. I've taken you 11 minutes over. I apologize for that. If there are any questions, I certainly will open up the floor now. But as is always the case, I don't want to abuse your time. So if any of you have follow-up questions on any deal you're looking at, that you're working on, that you're thinking about, please send me your question. I will give you my answer. And unless you engage us to do some work to help you on the matter, this interchange of you asking a question and me answering it will never result in a bill or a legal charge. That's our investment in you. That's our investment in your success. See it as an extension of your in-house counsel. We are those people for you. We fill that role for you. And so don't be shy in calling up or sending an email message and saying, Ren, I have this specific instance. What should I do? I will answer that. I'll answer it promptly, same day. And if I advise that additional work needs to be done, I will tell you what that work is, and I will even give you an estimate of what the legal fees will be so that you can make an informed decision if you want to go forward in that manner. So I will never leave you hanging. I'll never surprise you with a bill, and I'll never incur a charge unless we've agreed as to what that charge is going to be and what the scope of the work is going to be. And at 11:13, I am signing off at this point, And
Hey,
I will
Ren.
cease our recording. Oh, yes, Greg.
I just had, it's Greg, one clarification on your last bit, and that is, what if we have a capital improvement agreement where we are not withholding any funds, but we are requiring the borrower to do some work within a specific period of time that is on the property?
That, Greg, is where you're going to want to use what I mentioned before. You're probably going to want to use one of those tri-party capital funding agreements with the party who's supposed to provide the capital, where they acknowledge to you that under their operating agreement they have this obligation, that if they're called upon by the borrower entity to fund these monies, that they acknowledge that they have the obligation to do so, and that if they fail to do so, you as the lender, to protect your collateral, can make a direct call on them for those monies. And then you'll want to
I'm speaking specifically of the, from a title company standpoint, your mechanics lien endorsement, where you said if you're doing reserves, holdbacks, or impounds. What if you're just doing a capital improvement agreement instead, where you're not actually withholding any funds based on that, but you are requiring them to do future construction work or repair work?
Yeah. In that case, the answer is you likely will not get a mechanics lien endorsement, nor should you require one. You would handle it, in my opinion, by financial covenant, meaning you would have them covenant that they would perform the work and that they will do it lien-free. If a lien arises, they'll have 60 days to get rid of the lien, and their failure to do so will trigger a default. So in that instance, Greg, good question. You don't deal with the title company in that limited instance. You do it by financial covenants.
Okay, that's what I was looking for. I just wanted to make sure everyone heard that.
No, yeah, very good question.
Okay, thank you.
Anything else? And again, if you want to wait till afterwards, that's cool. Just wait till afterwards, send me your question, and I'm always happy to address it.
Thanks, Ren. Thank you so much.
Thank you, everybody. We will do one in November, and I hope that it's helpful. Susan, Cheryl, and Greg, we should have the podcast ready to go out by tomorrow, so we will forward that to you, particularly for the legal department and other people in underwriting who couldn't attend. So we will take care of that for you.
Great. Thanks.
Thanks. Have a great Monday. Have a great quarter end. Fix them up.
See you later.
Thank you.
Bye-bye.